Thank you, Paul. Just in the break, I was having a chat with another Paul sitting in the front here, and he raised a point that it's a good practice point for us, so let me repeat it through to you. I said that there's a transition window of 2 years during which you can register securities that are not already on a register somewhere on the new PPS register. And Paul said to me, well, what do you do in the situation where, say you've taken you've got a guarantee, and under that guarantee you've taken a charge over a piece of artwork in the corner, and that doesn't sit on any existing register, but then the new Act comes into play and the guarantor goes off to the bank and says, I need a loan of some money, and as part of that getting the loan, they offer up the same piece of artwork to the bank, who then registers it under the PPSA. You've then got a situation where you'll be dealing with the rights that you have under the transition provisions against the rights of the bank who has perfected a security under the PPSA, and that's going to be a very messy situation. And of course you'll have your rights still against the guarantor, but as we all know, in those situations the rogue never has any money. What that highlights to us is the importance of, even though you have a 2-year window in which to affect these things, is that your clients need to deal with them as quickly as they can and look at their existing securities and their existing collateral that they have security over, and move as quickly as they can to register them under the new regime in order to give the best protection that they can get at that point in time, and lessen the risk that they will be in a fight with someone else about whether the transition provisions apply over the registration under the Act. So that's for some clients will be a lot of work, and for some of you will be a lot of work in reviewing existing arrangements to determine what collateral there is and whether it's on a particular register at the moment that transfers across, or whether it needs to be registered under the PPSA. In terms of going back to our concepts and definitions, looking at third parties and enforcement, as I said just before the break, generally a security interest is going to be enforceable against a third party if the secured party has possession, control, or if they've perfected under the Act. So let's move to the concept of perfecting a security interest. It's a technical concept, it's particular to the PPSA, and it's a form of protection that is stronger than just mere attachment of the security interest. And the way that perfection is done in most situations will be by registration on the register. As I said, it can be in some situations by control, it can be in some situations by taking actual possession, but by far the most common way will be by the registration process. Something that I haven't touched on before, whilst perfection gives you protection against other people who come later in time or who are earlier in time and unperfected, it also has a major impact on the status and the priority in relation to what happens in an insolvency or a bankruptcy situation. If you have a security interest that is unperfected at the time of insolvency or bankruptcy, then you lose the benefit of the security and the collateral reverts to the grantor, or in effect to the insolvency practitioner, be that a trustee in bankruptcy or a liquidator. You then maintain a right to prove for the debt along with all the unsecured creditors, but you've lost the benefit of the security. So failing to perfect a security interest can have dramatic and drastic consequences for people in the event of an insolvency or a bankruptcy. again, it's part of the Act's idea that it's to give greater transparency to who has taken what security in what situations, and to try and avoid some of the messy fights that happen when companies in particular go into insolvency, and you have people coming out of the woodwork all over the place and saying, but I have security over this asset and I have security over that asset, and liquidators spending considerable time and money working out whether those securities are valid and binding and whether they form part of the pool of money available to creditors or go off to a secured creditor. So that's the major other consequence of not perfecting your security interest. And there are some other consequences there in terms of a buyer who provides new value can acquire the collateral free of the security interest if it hasn't been perfected. If you've got collateral that is required to be registered using a serial number, and that's things like motor vehicles, some boats, aircraft, helicopters and the like, then if a person searches the register for that serial number and doesn't find any security interest registered against that property, then they take it free of any encumbrance. So again, it's...
The date for that, the actual date of payment or the date of entering into the agreement to buy?
I think the Act says as near as possible to when the purchase happens. There's an exception for licensed motor car traders where there's a day and a half provision. So if you would have, you don't necessarily have to have, if you would have searched the register a day and a half before you purchase a motor vehicle for new value, then if it doesn't show up anything in the register or would not have shown up anything in the register, then you take free of any encumbrance. Otherwise, as I said, I forget the exact words, but it's immediately or immediately prior to.
So what I'm getting at, on a purchase of a business where there's assets involved, is it like a conveyancing transaction where you do a final search before settlement and you run a risk theoretically in a couple of hours that it's there, but if you combine the business, you might do a search at the beginning of the act.
And I think you'd be prudent to do a search just before the transaction happens. And the other thing that brings up is making sure that you've got proper warranties in the agreement so that you've got some protection back against the seller. I'm sorry, the question might not have been heard right the way down the back, and that was how immediately prior to the transaction do you have to conduct the search of the registry? I hope that gives some sense to the answer. Let me talk to you very briefly about what are called purchase money security interests, because this is an important area of the way the new Act works. Purchase money security interests will have most common effect for us in terms of retention of title clauses or remolpa clauses. And what it gives is a person who is a secured party with a purchase money security interest gets what's called a super priority. Let me explain how that works. If you're in the business of providing widgets on credit, then before you supply the widgets to a particular customer, if you go through the process of registering your security interest in the widgets until such time as they're paid for by the customer, then you have what's called a super priority that will trump other priorities even though they are earlier in time. So what it's designed to do is, again, in a situation where there's a dispute about, in insolvency, about whether particular assets form part of the pool for distribution of creditors or whether they're subject to some security, is to take a lot of that uncertainty out of retention of title claims. Because if you've gone through the registration process under the Act, then you can say, I have claim under the PPSA for those widgets and I haven't been paid for them and I'm entitled to take them as a super priority. The rationale behind that is that those assets wouldn't be there unless the lender had advanced the money in order for them to be purchased, or if the person hadn't given the goods on credit to enable them to be sold on to third parties. And so they shouldn't be prejudiced by the fact that someone else has taken what we would call a fixed and floating charge over all the assets of the company. But importantly, the super priority has to be registered before the grantor takes possession of the widgets. Otherwise, it's still a security interest, but it doesn't have a super priority. That leaves the issue of, well, do you have to do this every time you supply widgets to a particular customer? And the answer to that is no. You can set up the super priority in such a way that it provides ongoing protection when you are supplying on terms of trade or on credit to people. So you need to do it once, you need to do it before you give the goods the first time, but then you can obtain the benefit of that moving forward and during ongoing supply.
How does that apply to existing removal clauses then? Because you're saying that you've got to register it before you supply goods on credit. Well, when the Act kicks in, I'm sorry, when the Act kicks in, there's going to be thousands and thousands of removal clauses out there that will need to be perfected. And these will be perfected after the goods have already been given to the grantor. How do we deal with that?
As part of the transition provisions, there'll be some mechanism of dealing with that. I'm not entirely sure how that operates. Again, it highlights the importance of reviewing the contracts and the dealings that clients have, so that before you send your next lot of widgets, that you've gone through the registration process. You can see that it's going to give rise to a lot of activity in the first few days or weeks of the Act, as everyone scrambles to register their interests and to register their purchase money security interests and to gain the best protection that they can. And one of the suggestions as to why the implementation of the Act has been delayed is that they're having trouble getting the register up and running. And so I expect that there's going to be considerable teething issues as we actually hit the ground and start running with this.
I'm just concerned that we can certainly get our clients to perfect their security arrangements with their credit customers, perhaps redo the documentation for the new Act. But I'm also concerned that when the new Act kicks in, that there might be a number of, if you like, my clients that have hundreds of thousands of dollars worth of goods out there on credit, which have already been delivered. And I'm just wondering how we actually you really perfect the claim or your remelpa clause on those goods. And I'm not sure whether, with respect that you even, assure the Act actually adequately deals with that concern.
Yeah, well, I have to say the purpose of this talk is not to delve into the particulars of each and every transaction. It raises a good point. It's one of the things that people need to consider. What's been happening in the background is that parties who regularly deal in securities, so banks and other lenders, have been working for a long time to put their procedures in place so that they do hit the ground running. A consequence of that for many small players is that they're going to be caught short, or they're going to find that they're scrambling to get up to speed with what's going on. And that is an opportunity for us as lawyers, is to give some proactive advice to our clients about what they need to do and what they should be doing over the next 3 months to review their operations to put themselves in the best position as possible so that they've got the best protection available. Let me just draw to your attention that there's a number of rules under which a person can acquire the collateral free of existing security interests, and I've set out a number of them there. The second last one, low value personal use property. There's a carve-out for people who are purchasing things that are of relatively low value for their own use. They don't need to go through a process of checking the register and making sure that it's not secured somewhere else in order to take it free of the security interest. It sounds simple at the start, but when you delve into it, the way the Act operates is you've got this amount of $5,000. So if you go onto eBay and you want to buy a stereo that's worth $4,000 and you pick it up for $3,500 and you think that's a pretty good deal, you got it for $3,500, it was worth $4,000, then you take that free of existing security interests. But if you go onto eBay and you see a stereo system that you think is worth $7,000 and you pick it up for $4,500, then there's an ambiguity about whether or not you get the benefit of the low value personal use property. The devil, as always, is in the detail. Let me touch briefly on enforcement as well. By and large, parties remain free to negotiate their own contractual terms so long as they don't conflict with the PPSA. So that means you can still have provision to appoint receivers and managers to take control of collateral. The Act doesn't import any higher requirement that you need to have a prior judgment first, but it does import an obligation that when you take enforcement, you exercise it in an honest and commercially reasonable manner. Honesty is a subjective requirement. It's very difficult to work out what a commercially reasonable manner will mean and how that will be interpreted by the courts. Chapter 4 doesn't apply, so the enforcement provisions doesn't apply if a receiver or manager has been appointed and the grantor is not an individual, so in terms of corporate insolvencies. And then there's a requirement that if a secured party is taking intangible property, that they give appropriate notice to the grantor and, if applicable, a licensor, and by using a method that's agreed in the security agreement. And there's also an obligation, that last bullet point should be pulled across one. There's an obligation, whether it's tangible or intangible personal property, that if there's a higher ranking secured party, they need to be notified and so that they can intervene. And in any event, if you're a second ranking secured party and you do take enforcement action to gain the collateral, then you still need to account back to the higher ranking secured party for their interest before you can take your interest. Are there any other questions on to the operation of the Act and the regime before I move on to the register and how that's intended to operate?
I just had a question. You mentioned that you thought that a security interest could be taken by possession of the property as opposed to registering the interest. Mm-hmm. I don't understand how that system would work, because let's say you loaned money to somebody and he provided his boat as security and he physically gave you possession of the boat, and then later he borrowed money from someone else and they then registered an interest over that boat. You have possession, but they've registered the interest. How do those competing interests get to be sorted out?
They get sorted out because you have the boat. So the person goes to enforce their security interest against the grantor, and the grantor says, I don't have the asset. And so that brings in, I guess, a requirement for people to do some due diligence when they take security, is to find out whether there are any prior securities, and probably sometimes, as you would do with a boat in any event, you'd want to make sure that you get a good look at it to see whether the person actually is in possession of it or not. All right, moving on to the register and how that operates. It's wholly electronic, so there's not going to be any sort of paper version of it. It'll be accessible at all times, and it operates on the basis of notice rather than document registration, and it does that via what's called a financing statement. So when a secured party takes their security interest, they have an obligation to fill out this financing statement, and that gets lodged with the registrar of the register, and then they have an obligation to give a copy of that to the grantor, and at that point in time it goes up on the registry, and it's searchable, and people can search by the grantor's details or by serial number if that's applicable. It's a civil penalty offence to apply to register a financial statement unless the person believes on reasonable grounds that the person described as the secured party is or will become a secured party in relation to the collateral. Once it's up on the registrar, then the grantor can say to the registrar, that's not appropriate, that collateral's not being given as security for this security agreement, and then the registrar will notify the secured party, who has, I think, 5 days in which to take it down or take steps to have the registration approved. And if that doesn't happen, then the registration comes off the register, and the secured party will have to go to court in order to get it re-established. So it can become a bit messy at that point if you've got a situation where for some reason a grantor objects to the collateral being put up on the register. The registrar has an obligation to remove that, and the onus goes back on the secured party to take steps to enforce their right to have it on the register, and they do that through the court process. Again, how that will actually play out will be interesting to see, because I guess it will go back to whether there's a good security agreement in the first place that clearly identifies both the security interest and the collateral, and then it'll be interesting to see how the courts actually deal with that, whether they're prepared to deal with that in some sort of expedited process, or whether things get bogged down in the system. There's a few more details here about the registration process, which sets out what I've just said, so you can read through them when you get the notes. And then what the Act does is it contains a number of provisions that are intended to preserve the integrity of the registrar. So what it does is it adopts what they call an exact match registration system that places a high onus on getting the information right in the first instance. And that's particularly applicable when you're dealing with serial number registrations, where you might have a VIN number that, I'm not sure, they must be 12 or 15 or 16 digits and characters long, and it's very easy for someone to key in the wrong digit or character. If that happens, then you don't get the benefit of the security under the register. So making sure that securities have been properly recorded in the register is going to be critical. And as I said, misleading registrations are ineffective. Outdated or misleading registrations can be amended or removed by an administrative or judicial process. And as we've talked about earlier, some of the interests that did not require registration under previous regimes will need to be registered in order to secure a priority. And the idea of all of that is to provide greater transparency. And then at the end there's just a little section about how you go about applying to correct the register. Right. That is all I wanted to cover today. I appreciate that it's very high view and very high level, and it doesn't really give you the detail that you'll need to be able to advise clients on the operation of the Act. But I hope it at least gives you an understanding of the Act and how it operates, so that you're in a position to learn more about it, and it gives you some tools that you can use to, or some books that you can use along the way. Thank you very much.
Thank you, Adrian. Well, I think because of the time, we're probably not going to be able to have a question and answer session, but I know that Adrian will be pleased to take questions on notice, perhaps when the notes are distributed. And I'm confident that Adrian won't mind me volunteering him that if you've got particular questions after reading the notes, you could perhaps email Adrian and ask him any questions. Listening to this talk, all I can say is that I'm now scared stiff of this legislation because it's so radical in nature. There are two people that I would like to thank especially for this morning. Firstly, I would like to thank Adrian for delivering a clear paper in this labyrinth of provisions. The second person I'd like to thank is a member of our list and Michael's office in Luke Hales. If you go into Michael's office being one of the most extraordinary land grabs in Owen Dixon Chambers for some years, you'll be confronted by a veritable slips cordon of people at the desks that face you. Well, Luke sits at second slip, which is pretty good because the wicketkeeper and first slip have been seriously challenged with their hand-eye coordination for all of their lives. But Luke, I'd like to thank particularly for organising this morning, and I'm really glad, I think, to see such a very large number of people coming together at 7:15 in the morning. I think that's a testament to you, Adrian, and the interesting subject matter of the paper which you've presented. So I'd like us all to thank Adrian for the time he's taken today.